Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We are here for oral argument and on the record in Siciliano v. State of Arizona, CV23-0156. Counselor, just a reminder that these proceedings are being video and audio recorded and live streamed, so please introduce yourself and your client as you begin your argument. Counsel for appellant, if you'd like to reserve any time for rebuttal, that's up to you. You have to watch the clock. Each side will get 20 minutes. Keep in mind that we've read the briefs, we've conferenced the case this morning, and with that, counsel, you may proceed.
Thank you, Your Honor. I would like to reserve 5 minutes of my time, please. May it please the court, my name is Chris Davis on behalf of the state of Arizona. There was a stipulation in this case. It wasn't written. It didn't need to be written. There's a stipulation that the parties had agreed upon the universe of facts and issues. And the issue for the jury at that point was solely what percentage of fault to apply to the non-party at fault. And that was the jury's role. When they came back with a 0%, they weren't operating within the universe of facts and issues per the stipulation.
Counsel, which stipulation are you referring to?
Well, in case law, stipulation is defined as an agreement.
No, I'm just asking factually.
Factually, well, it would be all the evidence that the plaintiff presented at trial, meaning they brought the expert.
I read your brief as talking about a statement made in closing as the stipulation. Now, maybe I've misread it.
Well, that's part of it. It's not evidence for the jury to consider as toward the verdict itself, but it is evidence of a stipulation. A stipulation does not have to be written. A stipulation is defined as an admission during a judicial
proceeding. My question,
proceeding.
counsel, is what stipulation?
The stipulation that, I'm sorry, Your Honor, appreciate it. The stipulation that there was a percentage of fault that needed to be applied to the non-party Navajo Mesa and ecology. That's the stipulation.
And that was made before trial?
During trial.
At closing?
And closing. That's a stipulation. That's all evidence of the stipulation was the actions of the plaintiff's counsel.
Counsel, I'll ask one more time,
Yes,
and we'll
Your
see
Honor.
if we can bridge this gap.
Sure.
What stipulation? Where would I find that? If I were to look for a line on a transcript, where would I find that?
Well, it's the whole of the evidence, Your Honor. It's the bringing the expert to trial that the plaintiffs did that brought no opinion against the state of Arizona, only opinions against the defendant. It is the argument made by plaintiff's counsel at closing, saying that you have to, he even said, quote unquote, I'm going to do the state a solid, meaning the burden of persuasion's gone. The stipulation takes away the burden of persuasion as to the state's non-party at fault. The stipulation is that the non-party had a percentage of fault that needed to be assigned to him.
I thought Civil Rule 80A says no agreement or consent between parties or attorneys in any matter is binding unless it is in writing or is made orally in open court and entered in the minutes. So going back to Judge Thumma's question, if it was orally is it written somewhere in a minute?
There's
somewhere?
no written. No, Your Honor.
Okay, so it's not a stipulation, say an agreement as we envision it under Civil Rule 80A, right?
Well, Your Honor.
It's not written.
It's not written.
And it's not in the minutes.
It's not in the minutes.
Okay.
Okay.
Was there a request for a jury instruction?
There was a request for jury instructions as to the fault of the non-party, of course, but not stipulation as we're saying here today, right?
Okay, so there was no request for saying, we want you to instruct the jurors that the parties have come to an agreement that, in fact, there's some fault has to be apportioned to the non-party at fault.
There was no jury instruction to that effect.
So you never requested such a instruction.
The agreement between our admission, like I said, in the Ogden case, there is a stipulation, and that was one of the things that was the court was informed to the court to overturn and grant a new trial in a non-party fault situation when there was no percentage of fault applied. There was a stipulation relied upon. And the language in the case law for stipulation, it doesn't have to be written. It is an agreement, admission, or concession, a concession made in a judicial proceeding by the parties for the purpose ordinarily of avoiding delay, trouble, and expense.
Counsel, isn't Ogden factually distinguishable?
Well, in the fact that there is a legal impossibility with the vicarious liability, I would say, But it goes more towards, again, it's stipulation.
Didn't Ogden involve an express stipulation? Paragraph 16 of that opinion addresses it.
It did.
And that's not what we have here, is it?
There's not an express stipulation in this case, Your Honor.
Thank you.
There's not a written stipulation in this case, Your Honor. The point of the matter is that the plaintiff brought an expert to trial. They said undeniably, with presenting an expert, and I understand the jury can disregard expert testimony. I do understand that, right? I fully understand that. They went to the effort to say that the truck driver sped an extra 7 miles per hour, which the 2 mile per hour thing isn't really relevant because the statute says you have to drive reasonably prudent for the situation, but that he sped into the crisis situation and he drove left into the decedent. So they brought that evidence themselves. We filed a non-party at fault immediately after the settlement, right? And under UCADA, you got to consider the settlement and any non-party at fault. We brought that information. We brought the non-party. The plaintiff brought the evidence. We agreed with it. There was no impeaching testimony whatsoever, no controverting testimony whatsoever as to the fault of the non-party. Had the jury come back with 1%, we'd been fine. That would be that that's again, it's the universe of issues and facts.
Counsel, if it would have been,
the STIP created that.
if it would have been 0.1%, would it have been okay?
Yeah, sure, but there's at least some fault because it's a matter of there has to be an assignment. The STIP is a byproduct of an agreement that makes it a universe of facts that the jury has to operate into. And
So
that
let
gets
me
the
ask
actions
you,
of the counsel that created the STIP with the argument and bringing the expert. Yes, Your Honor.
If the court were to find that, in fact, there was no stipulation, what would your argument be then?
Well, under Stiles, the question would be whether or not this is like an irrational verdict based on the evidence, right? And beginning the fact that it's there's literally no impeachment or contrary evidence that was introduced that the non-party didn't have some portion of fault at all. And Glazier shows how small that has to be. The non-party at fault in Glazier, there was a similar situation where the state brought a non-party fault against a truck. The only evidence deduced at trial was impeachment cross-examination by the plaintiff's counsel, and the court said that was enough for the jury to come back with 0%.
And we're familiar with
Yes,
Glazier.
yeah. Well, that's the point, but that's my point here, is there's not even at that point. There's not an indicia, there's not a scintilla of evidence of contrary or impeachment evidence on the expert's testimony that the non-party bared some fault.
Counsel, let me
And I
ask
understand
you-
they can disregard that, and that makes it 0 okay. Yes, Your Honor.
You're not arguing that evidence was either improperly admitted or improperly excluded, right?
Correct.
You're not arguing that the jury was improperly instructed, given what was and was not requested.
Correct.
You are instead arguing that the jury had to, as a matter of law, attribute some portion of fault to a non-party other than 0.
Correct.
What is your best case for the proposition that, other than possibly a new trial, which was denied by the Superior Court, a ruling that we owe great deference to, that was legal error?
Well, under Rosner, under the UCADA, right, that they have the primary intent is that the trier of fact, in most cases, the jury to apportion fault among all joint tortfeasors based on facts presented at trial. The STIP, which we believe there is a STIP, there is no facts that, in the universe of the facts of the case, even without a STIP, there's no facts that show that they couldn't be apportioned at least some fault.
They could have. Clearly, the jury
disregard. Yes, sure.
The jury could have come up with a different verdict. I don't think anybody views that differently, but they didn't.
Correct.
And so again, I'm looking for why that's legal error as opposed to a disappointing, from your perspective, finding by a jury.
Because I believe it's it's contrary to the weight of the evidence for motions for new trial, and it's contrary to law because there was simply no evidence to support a 0%. The evidence was brought by the plaintiff themselves. They brought the expert. They brought everything in. They specifically said over and over again, the non-party bears fault, the non-party bears fault. The state merely agreed with them. And in closing, they said, it should be, there absolutely should be a portion of fault. I know lawyer argument is not evidence, but I think that again goes to evidence of the STIP, and that it's merely a job of the jury at that point to decide some percentage of layer of fault. Some percentage. It could be 0.1, it could be 1, and the fact that they didn't that is against the way of the evidence and contrary to law. That's my point. Briefly, there's a lot of talk about Article 18, Section 5 in counsel's brief. We think it's irrelevant. It's only dealing with contribution comparative of the plaintiff. Not relevant here because we're dealing with contribution of the tortfeasors. Again, like I said, at the end of the day, we think the jury had to decide a percentage of fault, and we should be entitled to a new trial under Rule 59. And if you don't have any further questions, I'll sit down.
Sure. Thank you, counsel.
Thank you.
Mr. Abney.
Yes, sir.
Let me get my paraphernalia here.
My Latin teacher used to call it impedimenta. She had a way of that.
Article 18, Section 5 matters
Sorry,
of
counsel,
great...
will you just announce your name and your
Oh, I'm
party you
sorry.
represent first? Thank
I
you.
got so excited. My name is David Abney. I represent the plaintiffs' appellants. Thank you very much for the opportunity to have a discussion with you today about the case. I appreciate
You're
that.
representing Appalese, correct?
Sorry, yes, I'm representing...
Just wanted to make sure.
Lord, I'm doing really well so far.
It's so unusual to see you on this side of the courtroom.
I know, it
I
feels
almost didn't
odd.
recognize you.
The whole perspective is different. But... All right, let's resume. I'm here once again to defend the Arizona Constitution, which I have failed to defend very well recently, but I'll keep trying. Article 18, Section 5 matters a great deal. It's incredibly, it's unique. We borrowed it from the Oklahoma Constitution, which, by the way, was the longest constitution ever written for any state. They threw everything but the kitchen sink in at the height of the progressive era. And the biggest concern for this clause was that the common law courts had contributory negligence and assumption of risk, and if you took them literally, as many common law courts did, any hint of contributory negligence and you were out the door. That was the end of your case. Even if your percentage was 0.01%, it didn't matter. So in Oklahoma and in Arizona, this was adopted. It mattered a great deal. It came under discussion on December 5, 1910 at the Constitutional Convention, and they decided to adopt it. There were three proponents of it, very vociferous proponents, who became justices on the state Supreme Court. Alfred Franklin, I think. Anyway, Justice Franklin, who became our first Chief Justice, served from 1912 to 1918, and Cunningham and Albert Cornelius Baker. But the comments of Franklin at the convention, I think, really wrap this up. It's page 884 at Goff's wonderful records of the convention. I am willing to support the language of the Oklahoma Constitution for the reason that it leaves this question of assumption of risk and contributory negligence as a fact to be determined by the jury and not as a question of law to be determined by the court. But what my colleague across the aisle is trying to argue to you is that you should treat it as something that the trial judge could take hold of and say, well, you're just wrong about your apportionment of fault.
Isn't that an argument, though, a little more nuanced than that? And that refers back to the conversation that you just mentioned in 1910. Was that with respect to plaintiff and defendant, or was that with respect to plaintiff and defendant and others, sort of non-parties? I'm guessing the former, not the latter.
Well, they wouldn't have been concerned with non-parties. That concept would have never occurred to them. There was no non-party system.
Well, and that's my point. So if it didn't exist at that time, it is fair, I think, to maybe presume that 18 Section 5 was addressing something different than what we're asked to address here.
I don't think so. I think the fundamental point is the jury is in charge of issues of contributory negligence and assumption of risk. The Arizona Supreme Court has said when you're talking about comparative fault, you're really talking about contributory negligence. So it's the jury's job to deal with comparative fault, contributory negligence, and assumption of risk. We have this non-party who's sort of a proxy for a defendant.
Well, maybe, maybe. I think that might overstate things a little bit. But your point about what happened in 1910 and then 1912 when our Constitution was adopted in Article 18, Section 5, which I think remains unchanged today, although...
It hasn't been amended.
Yeah. Address something different. than sort of the comparative fault world that we're in now. I think that's what you've said. And I get your argument that 18.5 talks about the primacy of juries, but I don't know that binds our decision today in how you address the responsibility or the fault of an entity or individual who's not a plaintiff or defendant.
And I think Stiles made a point about that. At one point it said, well, it's designed to protect the plaintiff. And that's what the analysis was about. But the words are so broad and so clear, I think it simply leaves it up to the jury in all cases whatsoever. And this is one of those all cases whatsoever. It's maybe not quite what the framers envisioned, but it's awfully close. And they put in that broad language for a reason, because they knew the law evolves and changes, and they wanted to make sure that this decision is going to stay with the jury. Our legislature pulled the Constitution into the Uniform Contribution Among Tortfeasors Act in the first section there, 12-2605, when they quote the language out of the state constitution. And it's right, so they pull it right in there, and that's what we're supposed to be doing. It's up to the jury to assess and apportion degrees of fault. In this particular case, the jury had evidence that the truck driver was 2 miles above the limit and maybe was drifting a little bit in the lane, and that was it. As I was driving down here today, I was over the speed limit all the time. I mean, I didn't mean to be, but I was, and I do it all the time. Every driver, I think, does it regularly. And so the jury could say, well, so what?
Let me ask,
I don't think that really was the problem.
One way to look at this case is what the jury did is a little surprising. I mean, for the zero for the non-party at fault. Would you agree with that or not?
No. When I and I'm not saying that merely as an advocate, but I looked at this and I thought, well, what did this driver do? He came around the corner and he's driving this big vehicle, the truck driver, commercial driver. And all of a sudden, in front of him is another vehicle, and there's really nothing he can do. If there had been a four-way stop, as they were advocating, or traffic control signals or signs or whatnot, then maybe you could say, well, he should have stopped, for instance, if there's a four-way stop. There's things that could have been done, but the state didn't do them. And because the state didn't do them, this poor driver, I think reasonable jurors could say, okay, so he's a couple miles over the limit, and he's drifting, that doesn't matter.
So he, though, and his employer were joined as defendants for a time, right? And then they reached the settlement agreement.
Something happened, they're gone.
And what of record do we know what that something was, if any?
Nothing that I saw on the record to say exactly what happened.
A dismissal order, request for dismissal?
Yeah, they're out, yeah.
Okay. And to follow up on Judge McMurdy's questions, were there, other than allocation of fault instructions, were there instructions about that dismissal, about the fact that he had been a party requested, but then not given? Was there anything like that?
I don't remember any instruction to that effect or any discussion about it.
Okay.
There was no written stipulation, no Rule 80 stipulation. There was no other written stipulation anywhere. There's nothing in the minutes. What you had was, and I quoted in the
Counsel.
Oh, go ahead.
I did say it first. The position you're taking now is different than what was argued to the jury. I mean,
Well, I was just getting there, but yes.
So you have a case where you have a settlement with the non-party at fault. So, okay. You have the plaintiff's lawyer stand up and say, they're at fault, maybe minimally, but they're at fault. And you have the state saying, they're at fault. Everybody acknowledges to the jury, they're at fault. Then the jury goes, nope.
I think somebody said nuanced a minute ago. I think there's a little more nuance than that. Mr. Breyer was tiptoeing through the argument because he wanted to explain to the jury that you could allocate fault to the driver.
I said it. I'm going to make it easy on you. They're at fault.
Right, when he says, I'm going to give the state a solid or do the state a solid, and how are we supposed to treat that? Do we just ignore it? Or how do I reconcile that in my mind?
Well, in the closing argument, he says to the jury, the judge isn't going to give you any calculation. There's no sheet, there's no guidance other than nine of you looking at what's happened here and saying who should bear most of the fault and who else has responsibility. I would argue to you that speeding toward an intersection where you can't see, there's some, though smaller, share of fault. What about the state? Well, the CC argues that the state had a long-term fault because it didn't do anything. He says that the two other people, which is Paolo Siciliano and Pablo Mesa, were at the wrong place at the wrong time, did the best they could in a matter of seconds. I would argue this is not an equal amount of responsibility. He's suggesting a certain percentage of fault. It didn't add up, but 65% to the state, 10% to Pablo Mesa and Pablo Siciliano, 10%. And that's the way he presents it to the jury. But then at that point, it's completely up to the jury to decide what to do.
But the point being, he never once indicated that the non-party at fault was not at fault.
He did not present, no, he did not present that, you're right, he did not present it that way.
He
to the
never
jury.
argued it that way, and in fact, the evidence presented by your client
Right.
was in fact that maybe to a much lesser degree,
Right.
but
And that was expert testimony, which the other side said, okay, we want an instruction on expert testimony that says it's entirely up to you what do you do with expert testimony. And this is argument of counsel, and they wanted an instruction on that, and they got an instruction that argument of counsel is not evidence, is not binding on you, you decide what to do. Mr. Breyer had a difficult task here. He didn't want to insult the intelligence of the jury by saying, you shouldn't do anything in relation to fault. And I'm sure he was hopeful that if he had said, well, 100% fault this person, 0% this person, juries, they would look at him and go, yeah, the world is not black and white. But the jury reached the decision that in this case, maybe it is black and white, because they could forgive the commercial driver for not driving better, given the fact that the state had not done its job of putting in a four-way stop or some other way to warn people and make sure this wouldn't happen. So he did a good job lawyering, but it wasn't a stipulation. It doesn't bind the parties in any way. It was just a way of presenting the evidence in a way that the jury would find palatable.
well, I tend to agree with you that it wasn't a stipulation, but was it a concession? Because we said this agreement, stipulation, agreement, concession. Was it a concession?
I need a thesaurus.
Well,
You
did he
could-
concede fault?
A jury could look at it that way, or a jury could say, he's making the best argument he can in a tough case.
Boy, that's nuanced.
Yes, it is. But juries, you get, individually, it may not be the brightest people on the planet, even if you got a PhD on your jury. But you take them as a group, they can work through things and see things that you would never think about until you talk with them after the case and they say, well, we decided this way because, and you're going, well, of course you did. Now that I think of it, that's the only way you could have decided it, isn't it? And
Mr. Abney, let me ask, my recollection of the record is that both counsel focused on allocation of fault in closing.
yeah,
And the jury then allocated fault. Now, that's what that allocation was, is why we're here.
Right.
But the thought that they somehow, and I don't know where this would take us, but the thought that they did that accidentally doesn't make sense.
oh no, this
that
was intentional.
both sets of attorneys absolutely focused them on what they needed to do, and they did what they thought was right, and the question is whether that withstands legal scrutiny.
Well, I think it's eminently reasonable. They had a difficult situation. They felt, of course, more that the state was more at fault than Paolo, and it's 51-49. That's about as good as they're going to do it. It probably never occurred to them to put 50.59 or whatever, some percentage, but you get the impression, and a reasonable inference from what happened is the state's a little bit more at fault. Paolo is a little bit less at fault, and that's what we're going to decide. And as far as Pablo Mesa, no. He didn't drive as bad as we drive every day, so we're just going to let it go. And they did, and that's a reasonable way to look at the evidence and what was presented to them. I'm sure, given that sort of careful calculus, that they were listening very carefully to the closing arguments. And they read their jury instructions carefully. And somebody might have said, well, look, this lawyer said this percentage, we have to do that. And somebody else pull out the instructions and say, no, we don't. We don't have to follow what the lawyer tells us. That's not evidence. We have to follow the evidence. We have to take a look at what the experts said and figure out, well, 2 miles above the speed limit, Really, come on. Drifting a little bit in your lane? No, that won't do it. It's a close case. But I do think it falls within it's an outgrowth of the Constitution, the idea that the jury gets to decide these cases, in all cases whatsoever. You would be, I don't think there's any stronger clause in the state constitution. I thought Article 18, Section 6 was pretty strong, but I learned differently recently. But this is very strong and very clear and as broad as you can possibly get, and aimed to cure an evil of judges taking over for juries and wreaking havoc in the middle of, we were industrializing like nobody's business at the end of the 19th century, beginning of the 20th, and so many people were getting injured. And businesses and corporations were using this as an out to avoid paying damages.
Other than the anti-abrogation provision, does the prohibition of the courts commenting on the facts have any application here or not?
I don't think anybody raised it.
Okay.
I don't remember it, but it
I
can
don't
be.
remember that either.
I thought about it a couple of times as I was preparing the briefing and preparing for oral argument, and I thought, but there really wasn't any comment on the evidence. The instructions were instructions that the party agreed on, and they were consistent with Arizona case law. And they really informed the jury that, hold on here, when it comes to argument of counsel, you're in the driver's seat. When it comes to expert opinion testimony, you're in the driver's seat. And when it comes to apportionment of fault, you decide. You're the only ones who do get to decide. I could go on to praise the Constitution further if you want. But, I did want to mention Chief Justice Franklin. He served on the court from 1912 to 1918. Then he was with the Internal Revenue Service in a position for a couple of years. Then he became a hermit. And I don't know if that was because of his work with the federal government. But he was seen around town and in the Southwest and in Southern California and the desert areas for decades after that, until the early 1950s, and then he just vanished. Nobody knows what happened to him. But he left a legacy for us, and this is a good legacy to leave. Thank you.
Mr. Abney. Mr. Davis, you've got about 10 and a half minutes for rebuttal if you'd like.
Thank you, Your Honors. I'll be very brief. To follow up on Judge McMurdy's thing, I do believe it's a concession. The weight of the evidence, there was an admission. Trial record in two parts, January 24, 2022 at 169 and 198. Plaintiff's counsel specifically asked for 10% of fault against the non-party. And then the portion that my colleague raised was same date at 158, 160, when he said he made a mistake. There's one of the timings of the settlement, though, also leads to the fact of maybe stipulation not being in the record. The joint pretrial statement in this case was filed pre-settlement with the trucking company. So there wouldn't have been an opportunity to put something in writing at that point in time. And in fact, I filled in on this trial as a last moment because my colleague got COVID, and I came in a few weeks beforehand. And then I think we were a little surprised that they brought the expert at the time, but of course I figured out strategy-wise what that was. They didn't want to argue an empty chair in one respect. And they conceded.
Is a concession binding on a jury?
Well, it's a stipulation. And per the case law says the only way.
Let's stick with concession.
Yes.
Is a concession binding?
I would argue that it is. It creates the universe of facts and issues for the jury to decide. And that creation of the facts and issues is a percentage of fault. Everybody admitted that there should be a percentage of fault. Everybody admitted, as with the law, that it was their the duty to, they can disregard, again, expert and stuff, but once that stipulation or concession came in, it creates what's known as a
So you
stipulation.
believe there's no distinction between a stipulation and a concession?
Well, the language, the definition of a stipulation has in the case law, has the word concession in it, in a judicial proceeding.
What percentage did the state argue?
5%.
5%.
Yeah.
So there wasn't a concession on fault?
Not on the percentage, not the allocation, that's up to the jury. It wasn't a concession to the percentage. It was a concession that there should be a percentage, and not to the actual number. And that's the realm of the world that the jury had to come in on. It's at least some percent. It's like, and to counsel's argument about, some argument about potentially wreaking havoc on how this interacts in the jury. This is a very thin, issue. Like I said, if there had been any impeachment evidence to the point of a cross-examination, a line of cross-examination per Glazier jury, that's within the realm for the jury to say no percentage of fault on a non-party. It doesn't have to be great at all, but there simply was not even the scintilla of contrary evidence, and I believe that does go towards concession. And the argument simply is, what should that percentage of fault been, regardless of the number given by the plaintiff and given by the state, it needed to be a number. And if you have no further questions,
Thank you.
thank you, Your Honors.
Counsel, thank you for your argument today. Thank you for your briefing. We'll take the matter under advisement and issue a written ruling in due course, and we are adjourned.